Hi there. In this politics topic video from Tutor to You, we're going to take a look at some of the broader sources of the UK's constitution. We have a separate topic video looking at constitutional statute law, so do take a look at that one. And in this case, we'll be looking at some of the other sources, including common law, conventions, works of authority, and international treaties. Common law is law that derives from customs and particularly judicial precedent rather than statute law. So statute law are acts of parliament. Common law is often regarded or described as judge-made law. So in other words, when judges reach rulings on cases that they are hearing, that in turn becomes the law of the UK. In coming up with common law, courts look to the decisions of previous rulings, and if there is a similar case that has taken place in the past with similar circumstances, they apply the decisions from that particular case to the current case. In other words, judges apply the principle of stare decisis. They use the reasoning used in previous similar cases. However, we know that not every case is going to have a precedent. There is not always going to be a case that has been similar to the one being looked at today. So if the case currently under consideration by a judge is very different to previous cases, or if the circumstances are different, then judges in the UK have the authority to directly resolve the issue. That judge's decision then binds future decisions by judges on similar cases. In other words, the judge has created common law. They have created judge-made law. Just some examples here of common law in relation to powers of the executive, the government, declaring war, committing troops to armed conflict, the granting of passports, the issuing of pardons, and indeed signing some international documents and agreements. These have all been established as common law by UK courts. Some interesting examples here. The McCormick versus Lord Advocate in 1953. This actually enshrined the official numbering system for monarchs. In other words, the use of the Roman numerals and the way that the monarchs were described. Interestingly, we have a lovely quote here from Lord Reid from 1969, where he actually effectively set common law on parliamentary supremacy or parliamentary sovereignty. In other words, he embedded the concept of parliamentary sovereignty into UK common law and made it part of our constitution. And he said, "It is often said that it would be unconstitutional for the United Kingdom Parliament to do certain things, meaning that the moral, political and other reasons against them doing so are so strong that most people would regard it as highly improper if Parliament did these things. But that does not mean it is beyond the power of Parliament to do such things. If Parliament chose to do any of them, the courts would not hold the Act of Parliament invalid." In other words, law made by Parliament, statute law, is the supreme law of the land. The second source of the Constitution that we're going to take a look at is a constitutional convention. Now, this is an unwritten procedure or custom or indeed a ritual followed by one or more of the key branches of government, the executive, the legislature and the judiciary. Conventions exist in both codified and uncodified constitutions. So, for example, there are plenty of examples of conventions in the United States, which has a codified constitution. In many countries, there's uncodified constitutions. In fact, the majority of government functions are based on conventions, in other words, customs, traditions, and unwritten procedures. And for the most part, they are often surprisingly strong and long-lasting. Human beings seem to be fairly averse to changing rituals and customs. Here are just a few examples that you could use to illustrate any questions that you might have on constitutional conventions as a part of the UK Constitution. The top two on the left there come from our old friend A.V. Dicey, and he pointed out that ministers resign when they lose the confidence of the Commons. Now, that isn't written into any law anywhere in particular. That is a convention. It's also a convention that the monarch will grant royal assent to bills passed by Parliament. There is no law that requires the monarch to do so, but the monarch has done so since the early 1800s. In fact, one of the most unusual conventions, and perhaps most surprising, is the fact that we have a Prime Minister. This is indeed a constitutional convention. It was only really first noticed or mentioned as recently as 1917, even though the post of Prime Minister has been in existence for some time. But this is a constitutional convention, as is the existence of political parties. The Salisbury Convention is often the convention that is perhaps most mentioned by students in exam questions. What the Salisbury Convention tells us is that bills that originate from a government's winning manifesto will always pass unhindered through the Lords. In recent years, this has become a little bit debatable. With a coalition government, there is actually no winning manifesto, for example. With a minority government, it's arguable whether there is actually a manifesto that effectively gives the government a mandate to do whatever they wish in relation to that manifesto. Other key conventions, the Speaker of the Commons, currently John Bercow, they will stand unopposed in a general election. In other words, the other parties will not put up a candidate against them. Occasionally, that convention does not hold, but for the most part, it certainly does. In terms of the executive and the cabinet, there are two key conventions that students need to know. The first is collective cabinet responsibility. This means that the cabinet will always, at least certainly in public, uphold the party line, uphold the government line. They will always support the government's policies and approaches. Individual ministerial responsibility effectively refers to their own personal conduct and that they need to take responsibility for their own conduct in their own departments. Finally, on the list there, the idea that Parliament will not criticise the judiciary. This hasn't always been the case, and certainly there was plenty of evidence of this perhaps not being quite as strong a convention as we perhaps thought. For example, when Theresa May was Home Secretary, often criticising judges in their application of the Human Rights Act, for example, in relation to deportation of suspected terrorists. Works of authority. The top three on the list there are authoritative works that all students need to know the authors and the names of. Just take a moment to look through those. Bagehot's English Constitution and Dicey's Introduction to the Study of the Law have remained unchanged since their introduction. Erskine May's Parliamentary Practice, first published in 1844, is in fact still updated today as a way of understanding exactly how Parliament continues to work. Arguably, there are more recent authoritative works as well. For example, the constitutional expert Professor Vernon Bogdanor and his work, The New British Constitution, published in 2006. International treaties form the final part of the sources of the UK Constitution for the purpose of this topic video. Some treaties ultimately become Acts of Parliament. In other words, they are fully incorporated into UK law. A good example here would be the European Convention of Human Rights, which became the Human Rights Act in 1998. But this is not just a modern invention. The Treaty of Union 1707 ultimately became the Acts of Union, linking Scotland with England and Wales. European laws, in terms of regulations and directives, have impacted on the UK. So European regulations apply directly in the UK without any further intervention or involvement by Parliament. European directives are adapted into UK law to be a little more specific and linked with the needs of our country. Clearly, this will change after Brexit. The Ministerial Code, which you could also argue is another source of the UK Constitution, does actually require ministers to comply with international law, although controversially it doesn't actually tell us whether domestic law or international law takes precedent in the event of a dispute. This will clearly be resolved on a case-by-case basis, and you could argue, depending on your point of view, that this is both a strength and a weakness of the UK's uncodified constitution. Don't forget to take a look at the topic video that we have on constitutional statute law. For more advice, guidance and support, do take a look at the Tutor to You website and our YouTube channel. Thanks for joining me today.